Welcome everyone. Welcome to today's webinar. We'll be talking about protecting your brand and business. We'll be kicking off in a few minutes. We just want to let everyone filter in. We've got quite a big crowd today. But in the meantime, feel free to let us know whereabouts you're from and what industry your business is based in, just in the chat box below. Hi, Ellie, welcome. Nice. It's good to see a mix of the states. Also, can we get a bit of a sound check? How's the sound on everyone's end? Awesome. Cool, we'll give it a few more minutes. Thanks for that, Roy. Just a bit of housekeeping as well, everyone. Throughout the course of the webinar, Damon's obviously going to be running through some content, but if you'd like to ask him a question, please use the Q&A section. You'll see it's down the bottom at Zoom, not through the chat. Just as you can see, there's a lot of people commenting and it's a little bit difficult for us to keep track of. So if you pop a question in that Q&A box, we'll endeavour to get to that towards the back end of the webinar. Okay, I think we'll kick things off. So we've got a bit of an agenda here for everyone just to keep track of. Obviously today the focus is on brand and business protection. And so Damon's just going to be providing a high level overview on intellectual property and then the specific ways in which you can protect your brand. Also, you'll see there enforcement's a big part of that, and then assigning and licensing intellectual property. As mentioned just before, please submit your questions via the Q&A section, and we'll save some time towards the end for Damin to answer those. Just a quick one as well about LawPath. I know a lot of you will be existing users, but we've invited some people through our partner networks, so hello to those people. And then anyone that hasn't seen the platform before or used the platform, just a quick little rundown. So, the LawPath platform is an all-in-one business hub. It's very much designed to provide you with all of the tools that you're going to need, at least from the legal side of things. Access to our legal document library, e-signature, and then obviously tying in legal advice. So, speaking with someone like Damin, the platform now has the ability for you to book in calls and consultations on demand. And then the last part of that as well is, registering companies and starting businesses, and also, trademarks, which will heavily feature today. But I'll hand it over to Damin to introduce himself.
Hello, everybody. Nice to see you in today. Thank you for joining. If you've been to my seminars before, well, thank you for coming again. Now, I've been a legal practice director of a couple law firms for many, many years. I have acted in various high-profile trademark infringement and copyright matters. I act for about 17 software manufacturers, and we do the enforcement and compliance of that software by demanding and issuing legal proceedings to enforce the copyright within that software. We also are generalist lawyers, so we do a lot of capital raising for startups. We do a fair amount of employment law and general commercial and the commercialization, I guess, of intellectual property. I've worked from various companies, from startups all the way up to listed companies, and I am the legal practice director of LawPath Legal. All right, so what is intellectual property? You've heard it before. You might not know how it can be defined or classified. It falls into different categories. So the first one, you have patents, and we'll go into patents briefly in the next slide. We also have trademarks, designs, circuit layouts, plant breeder rights, and copyright. Now, we're not going to get into designs, circuit layouts, or plant breeder rights, but it probably is worthwhile to just touch base on what they are. Designs is circuit boards, semiconductors, the chips that are in your phone, those are potentially the designs, and you can register and protect those. Circuit layouts, that's circuit layouts. Designs is the shape of a normal bottle, the shape of a Coca-Cola bottle, for instance, and plant breeder rights is similar to your buffalo grass, where you're actually creating a seed using newer technology to create something new. And then in copyright, I'll get into that, but it's the only one in Australia that doesn't actually need to be registered to be protected. So we'll start off with trademarks. A trademark is something that you normally use to be either the name of your business, the name of your product, the logo, the slogan that you have. So examples of a trademark would be your logo, your name, the purple, for instance, in the Cadbury chocolates, that is being trademarked. The golden arches is a trademark. So that is essentially what is a trademark. It's a word or logo, and there's different applications that you can make to protect those. Now, I would like everybody, if you have questions, try to put them in now, and as I go, I can try to answer the trademark questions while I'm dealing with trademark and the copyright questions while I deal with copyright. But that's essentially what a trademark is. Now, when you go to register a trademark, I get a very common question all the time saying, I already have Jim's Mowing as a business name, or let's call it James Mowing as a business name. Isn't that good enough? No, the answer is no, it's not. It's not just because you have a business name, or just because your company is incorporated James Mowing, doesn't mean that you've protected your brand. The way that a trademark works is it's similar to a charge over an asset. It's the first come, first to register gets the first protection. And it's only if you've been using that name for a long time, well before someone registered, would you maybe have some kind of protection. So to give you an example, you've created a business name, ABC. You've created a company, ABC Pty Ltd. You've been trading for 5 years. And as you've been trading for 5 years, a lot of people become to know you as ABC. And then a brand new company comes along and starts another company called ABC Holdings. You're able to register at that because it's not identical to your business name. And it's not identical to your company because it has the word holdings at the end of it. And then they start trading. Now, you might want to stop them from trading as ABC Holdings because you have that brand already. But if you haven't registered the trademark, you might not be able to stop them from trading as ABC Holdings. More importantly, if ABC Holdings goes and registers a trademark before you do, they, at first instance, has a better right to ABC than you do, even though you might have been using that name 5 years earlier. If you haven't registered a trademark, and if someone starts trading with the same name as you, and they go and register a trademark, the only way for you to overcome that and and be able to keep your name is to make an application to have their trademark set aside. And that would be very, very difficult. And we see this quite often, that a new company enters the market and then uses the exact same name, and the person that had the name first think they have protection. And that's just not the case, unfortunately. Now, so what you need to do when you register a trademark, well, the benefits are it protects you, and the protection starts from when you register it. It gives you the exclusive right to use that name in your class. And I'll get into what classes mean in the next slide, but essentially if you are selling alcoholic beverages, then you're protected in the beverage class. If you are manufacturing footwear, then you would be protected in the footwear class. And for each class you register a trademark in, you'll be protected in that class. So it's not uncommon that people have the same name or the similar trademark in different classes. And an example that had a lot of litigation in the past was barefoot. There was barefoot footwear and there was barefoot beer. Now, barefoot footwear was registered in merchandise, barefoot beer was registered in alcoholic beverages, but both of them want to get into merchandise, and then it became a big dispute. But that's just an example of the different classes and how they work. You get the exclusive right to use your brand or your logo in your class that you've registered your trademark in. And if someone else comes in and they try to register a trademark that's almost the same as yours in your class, IP Australia won't let that happen. And if they start using that name anyway, you can send a cease and desist letter and tell them to stop. Otherwise, you can issue proceedings against them to get an injunction stopping them from using that brand. Or you can get what's called account for profits, which is where you can seek them to deliver up all the profits that they've made by using the same brand as you, because customers might have thought that they're the same company and they've benefited from your brand. So you can ask for the profits that they've earned while using that brand to be delivered to you. Now we have a question. How often do trademark submissions get approved, and what happens if they're not approved? What are the steps? What are the costs for the initial submission, and so on? So the process I'll get into in the next slide, but if you make an application, and IP Australia will normally come back and they'll either say it's accepted for early acceptance, and then they will publish it internationally, let everybody know that it's pending registration, and give people to object to it. And if you get an early acceptance, normally it's going to get through unless someone else has the same name and they discover that that's being registered. But sometimes IP Australia will reject it. And what they do is they issue what's called an adverse report. Now that adverse report will say that either your trademark is too generic, so you can't register the taxi company in the taxi class because it's too generic. It stops every other taxi company from operating a business that's called taxi and company together. Or they might say that it's too similar to another trademark. And in that case, it's then up to you. There's there's several options, but option one is you can supply extra information to IP Australia, and you can say, well, I've actually been using this for years. No one has raised an issue in the past. This is the money I've spent on building this brand. These are the invoices that I've incurred in building this brand. No, there's been no other person that we can find that uses this brand. So we seek to have it approved, and IP Australia might then push it through. And if you get an adverse report because it's too similar to another trademark, there's a situation where that other trademark might be almost obsolete. The company that actually registered that trademark might not be trading. They might not be using it as a trademark. So you have about 12 months to then contact the other person that has the trademark and seek them to agree to register your trademark or seek the removal of their trademark if they haven't been using it in the last 3 years. So there's lots of different avenues you can take. The cost to prepare a response to an adverse report is generally around $1,500 to $3,000 because you have to collate all your evidence and you got to do a statutory declaration explaining everything, and it can be a fairly complex process. Now, the reason why, the way to avoid an adverse report really is making sure you don't choose a name that someone else is already using, and you do a little bit of your own due diligence before you create your brand. And before you start spending all this money on your Facebook advertising and Google AdWords and your graphic designer and so on, it's worthwhile to log into IP Australia. You can do a trademark search. It's really easy to use. You can just type the word of your business and see what comes up. And then when it comes up, you can see what class that word has been used in. And then you look to see, well, you know, I'm doing pet care and this person has the exact same word as me, but it is in automotive, and therefore I should be fine. I can go ahead and use that name. So you want to be able, you want to Google around, make sure no one else is using that name, and then you want to look at IP Australia and see if anybody else has that name before you start spending a lot of money on building your brand. Now, so as I mentioned, the process is you do your search, Google search, IP Australia search, see whether anyone else has it, and check the class, because someone else might have it, but not in your class. You then go and you make an application, and there's some videos online on how to do it, but there are a lot of tricky things about choosing the right class to put it into. Now, one application is the word ABC in class 44, for instance. Now, if you want ABC in class 25, then that's another application. And if you want your word and your logo, you might do just your word in class 44 and just the word ABC in class 25. That's 2 applications. But then you might want your logo in class 44 and your logo in class 25. That's now 4 applications. So oftentimes you'll get advice about, well, what should I do? Should I get all my applications done now? Oftentimes we say, well, it might be worthwhile to just get one, see if it gets through IP Australia, and then follow that up with more afterwards. But there's sometimes a strategy involved, and it's worth talking to a lawyer. Now, if you're on the legal advice plan, you can book in a call with the lawyer to strategize with you for 30 minutes on what classes, what you should be doing. Should it be your slogan? Should it be your word? Should it be your name? Do a search as well, see whether there's any other ones. And then after that, LawPath has a new offer that I'll get into, but they're doing free trademark searches if you upgrade your account. So if you're on the essentials and you go to the legal advice plan, you get a free trademark. If you go from the legal advice plan to the legal advice and accounting plan, then you get a free trademark. And LawPath is actually paying the disbursement as well to IP Australia, which is around $250. So that's just something to know, and I'll talk about that separately. Now, going back to questions, how long does a trademark, or how long does it take from start to finish? It's about 6 months. So you file your application. Normally within 2 months, IP Australia will get back to you. They'll tell you whether it's being early accepted, or they'll tell you whether it's being rejected. If it's rejected, they give you about a year to respond and collate all the information that you need to be able to respond. And if they accept it, then they publish it for around, I think it's 4 months, to enable other parties to object to your application. So it's generally speaking, it's a 6 months process from start to finish, but your priority date is from the date that you register. So once you register, the date that you're deemed to have started with your trademark is the date that it was filed originally. Now, I have a question that we have a global business with customers in more than 40 countries, and we're still growing. Does that mean I have to register a trademark in every one of those countries? Or is there a way to get it registered globally? So there's two ways to do it. Sometimes if you're trading just in Australia and the US, for instance, you might just register in Australia and then register in the US. Now, if you register in the US, you actually have to prove use as well. So if you just decide that you're going to get a US trademark, there is a requirement to supply evidence of your use in America to get your trademark approved. Now, the other way to do it is you wait until your Australian trademark is lodged and approved, and then once it's approved, you can ride off of that in Australia to the World Trade Organization. There's an application called the Madrid Protocol, where you can fill out a form and tick which countries you want, send it off to the World Trade Organization, and they will then send that application on your behalf to all the countries that you selected. And then that's a very quick process to go and get all your countries approved. The only problem with that is if you tick 20 countries and then you start getting adverse reports from each one, you might need to engage a trademark attorney in those countries. Now, I'll just explain the difference between a lawyer and a trademark attorney very quickly because I touched upon it. People probably think that an attorney is a lawyer, but that's not the case in Australia. In America, they call lawyers and attorneys. In Australia, an attorney is something totally different. A trademark attorney is somebody that has a degree and then has done a master's degree in trademarks and has become a trademark attorney. And so they can advise on how to register trademarks and enforce trademarks, but they're not lawyers. And it's the same thing as a patent attorney. And I'll touch upon patent attorneys while I'm on this topic as well. Lawyers generally actually don't touch patents at all. And the reason is that a patent attorney is normally someone that has a science degree. So they might have gone and done a chemical, bachelor's in chemical engineering, and then they've done a master's in to become a patent attorney. And then they now are patent attorneys in drawing designs and drawing the patents for pharmaceutical drugs, for instance. Or if you're going to register a trademark that's your software, then you'll normally get a patent attorney that has a computer science degree, and then they will then draft your patent, or an electrical engineer or a mechanical engineer and so on. So patent attorneys actually come with that science background, and lawyers, a lot of lawyers don't have that background and they're not patent attorneys. Some lawyers apply to be a trademark attorney, but they don't need to, because lawyers can be practice in trademarks as well. Does a business name registration suffice, or is a trademark registered? As I mentioned before, a business name does pretty much nothing for you. A business name, essentially, all that does is stop someone from creating the identical name. So if you have ABC as your business name, then someone else can call it ABC Company, ABC Holdings, ABC Trading, and your business name is not going to give you any protection at all. So you do need a trademark for that protection. Now, when you actually go through your application, you can do what's called the pick list, or you can choose your own list. The standard process is to choose the pick list. So you go into the class of goods, and there's 45 different classes. Some are goods and some are in services. And you go in and they have all these different words, and you can pick which words you want to apply to your trademark. The filing fee for that is $250. But if you want to do custom words, then the filing fee is $330, I believe, because it's more custom and it has to be reviewed more closely by a trademark attorney within IP Australia. Now, we have a question is, I have XYZ trademark registered, the business consultancy class, for example. How do I stop others from using the name and register as a business name or registering it as a company? You already have that protection in the sense that if you have the trademark in business consultancy, then anyone that registers a business name or a company with that name in it, and also in business consultancy, they're potentially infringing your trademark. But if someone registers that business name or that company and are not operating business consultancy, then you can't protect that name unless you go and you incorporate 25 different companies with your name and add the back of it, enterprise holdings, solutions, trading, and so on. And that's just indefinite. So that there's no point of going and registering dozens of companies just to protect that name. So the trademark's the way to do it. Same thing with business name. If someone wants a business name that's going to be exactly the same as your trademark, they're going to be able to do it by adding an S to the end, and then putting another word behind it. And you're never going to be able to have all the iterations of your business name. So the best one is just get a trademark. Someone registers a business name, they're doing it in the same class as you, then you can send a demand and demand that they stop. And if they don't, you can hire a lawyer to enforce your trademark. Now, if you don't want anyone to operate in any industry using your name, you could go and register a trademark in all 45 classes. The problem with that is that that's not going to be any good for you, because if you get a trademark, you've got to use the trademark as a trademark, and your trademark can be removed for non-use. So if you registered your business consultancy trademark XYZ in pet care class, and you're not doing any pet care, and someone else wants to start a company in pet care and they see your trademark, they can issue you a notice and you have to prove that you've used your trademark. And if you can't, your trademark won't be removed and they can come in. So there's no point of registering your trademark really in different industries that you're not participating in, unless you intend to go into there in the near future. Does it cost extra to trademark the name plus the logo, or is it part? So you can do just the word, or you can do what's called a composite, which is the word and the logo, or you can do image, just the logo. And it's probably best to talk to a lawyer about which one to do. There's 3 different kinds. Generally speaking, the name's going to be the strongest because the name is normally in your logo. So by just having the name itself, you also have the protection of the logo, because your name's normally within the logo. But if your logo is a meerkat, then you probably want to just go with the logo. Or if it's the meerkat with the name meerkat under it, then you might go for a composite, which is the logo plus the word. Now, international trademarks, as I talked about that, you ride off of the one that you've had registered. So you get it registered here, and then you go to the World Trade Organization, which is the division of the WIPO, and then you ride off of it and lodge it through the Madrid Protocol. Now, before I get into patents, I'll just see if I have a trademark named XYZ, and later on find a company called that, can I get the company to rename it? Well, if XYZ Pty Ltd is trading in the same class of services or goods that you're trading in, then yes, you can write to them and tell them to rename them themselves. And if they don't, you can issue proceedings against them for trademark infringement. And if they don't do anything, they keep on trading, you can go to the court and say, well, they're trading under the same name as me. They've created almost the exact same website domain as me, but included company at the end of it. They have a Facebook page that's almost identical to mine, but they've added an extra iteration at the end of it. They're benefiting because they're substantially similar to me, same class of services or goods. They're riding off of my brand. All the money that they've made, I want the profit that they've made to come to me, because they've infringed my trademark, and I want an order that they have to change their name as well. All right, so getting into patents. Patents, as mentioned, lawyers don't file or lodge patents. Patents attorneys do that. Those are someone that has a science degree. And that's basically, when you're getting a patent, that's to protect normally some kind of a software or an invention of some sort. And I guess an example of that would be, 3M, their removable hooks, that rubber the stretchy plastic that doesn't hurt the wall when it's removed, that would be a patent, for instance, and what's gone into it to make it. The iPhone, the technology within it, that's patented. A lot of people ask whether their software can be patented. Normally, it's certain components of the software that might be more likely. And there are people called patent trolls who, there's a company that's created a little invention and got a patent many, many years ago. And then they've never been able to commercialize it. So they sell it to what's called a patent troll. And they just go around the world suing people who've infringed the patent without even knowing about it, and seeking to recover damages as a result. I think that's all we can really talk about in terms of patents. Most of the time, you're going to have to go and talk to a patent attorney to determine whether you need to get your invention protected. But generally speaking, there's a slight layover, I guess, between trademarks, patents, designs, and copyright. I'll get into what copyright is later, but within patents and trademarks is copyright. Copyright's contained in there. So whenever you sue for trademark infringement, you also sue for copyright infringement. And whenever you sue for patent infringement, you also sue for copyright infringement normally, because copyright is the catch-all. And what that is, for instance, if you created the slogan, trying to think of a famous one. Think of one. The burgers are better at Hungry Jack's. That's actually a copyright slogan, but it's also can be trademarked as well. So if someone went and cut and paste and started using the burgers are better at Hungry Jack's elsewhere, then that would be breach of copyright, because those words are identical to what was originally created. Just having a look at some of the questions. So one of our members has taken the name of one of our landing pages and registered the domain and registered the business name and created an IG. What can you do about that? There are different processes in terms of the domain names. I haven't got into that, but you can lodge disputes where a domain's been registered in bad faith. There's some leading cases where someone's registered Shell, like the gas station, and then Shell's come in and been able to have that domain transferred over to them because it was clearly just registered in bad faith. But I won't get into that because that's another whole realm. But if someone registers a domain name that's exactly the same as your trademark, you then have to, it would be a pretty different, well, you have to do an analysis on whether that's a trademark infringement or not. Just having the domain name that's the same as a trademark might not necessarily be considered trademark infringement if they're actually not using it for commercial purposes. So that domain might just be sitting there. But that's probably beyond the scope of this presentation, because you start looking at all the factors that the courts have looked at in the past when considering whether a domain name in itself is an infringement of a trademark. Designs, as I mentioned, it's like the shape of the Omo package. It's the shape of the Coke bottle. It's probably, it is copyright as well, because when you do a drawing of what that bottle is going to look like, that is copyright in itself, whereas the 3D or the 2D image of that bottle is the design. Now we'll get into copyright, because copyright is the main area that most of you are going to be seeking protection. And we'll also touch upon common law trademarks as well. So that's where you actually don't have a trademark, but you want to claim a common law trademark. So copyright is anything that's put in written form. So a drawing, a logo, code when you're building software, writing an article, books, journals, singing music, writing films, and so on. So that's all copyright protected material. And this is the only area that you don't actually have to have a registration for. It just automatically comes into force. You do have to prove that you're the creator of it. And sometimes I say, well, if you want to protect that code, you're either going to use some software that you can use and show when it actually came into existence, or you might have it in SharePoint, or you might have it in Google Docs, or something that shows where that, not Google Docs, but something where it shows where that code has first come into existence. And so the first thing that when you sue for copyright infringement is you have to prove that you're the owner of it. And then you have to prove that you've created it and when you've created it. Because if you're claiming that someone's infringed the copyright, they might say, well, actually, we've created it first. And that's where it's going to become important that you're able to prove when you created it. Now, copyright infringement is where someone substantially copies your material. And so an example is where you have a website and you have the contents of your website, and someone goes and scrapes that and builds another website and it's exactly the same. That's clearly copyright infringement in substantial form. But there's a lot of cases in the federal court, well, what does substantial form mean? And you have to look at it by having a side-by-side view. And the judges have said, well, you got to look and see whether it's substantially similar by a lot of times having a side-by-side view of it. Is it in substantial form? Does it look the same? Does it feel the same? And that's another example of a case where they're talking about the look and feel of things can also be copyright infringement, where you've taken the design of websites and you have all the exact same tabs and all the same layouts. Back in the day when websites were built from scratch, that would be another example of a copyright infringement, just the look and feel of it, where the tabs are identical and the formatting of it is the same. And just having a look at the questions, I would like to appreciate some ideas that deal with a third-party owned domain name that is a trademark infringement. I can't get into that because that's a whole nother, that's probably another hour or 2 hour process, getting into what you can do to remove domain names, dispute domain names, and so on. Now, does a copyright for a new business logo belong to the company or the designer? Who is the contractor? Now, we do a lot of capital raising, and at the beginning, our companies were just startups, and they were just starting out, and they went to Fiverr and they got a logo made, or they went somewhere and they got a logo made. They didn't have any contracts in place. They didn't have anything. And now they're raising 10, 20, 30 million dollars. And those significant investors are coming back and saying, well, who built your first website, or who built the first piece of your code, or who built your original logo? And where's your agreement for that? And they might not have that agreement. So what they do is they make the founders become personally liable, so that if that original logo designer was to come after that company, that founder is personally liable to the company, to the investors, and they can take their shares away from them, the founder, if that contractor who built the logo sued later on, claiming ownership of it. So it's really important to make sure you have, no matter, it can be a very simple document. It just says that you own the logo, or you own the code. Or you can go into the LawPath platform and you can grab a contractor's agreement, you can grab a software development agreement, you can grab an IP assignment deed. There's various different documents to deal with it, but you don't own that logo unless you have an agreement. Generally speaking, there's no implied transfer of ownership. There's an implied license. So if someone built the logo and you paid them for it, there's an implied license that you're now allowed to use that logo pretty much indefinitely. But there's no implied ownership of that logo. And to get ownership, you normally need a contract in place saying that you own it. So that's either going to be by way of a contractor's agreement or by an IP assignment deed. A competitor is using your trademark in their Google AdWords campaigns. And so if you search your trademark word, their ad appears. Now, I had a look at this fairly recently, and I believe that that is actually permissible as long as that trademark isn't being visualized within the actual ad itself. So there was a company called Appster, and people used to say, have you been Appstered? Because they'd gone bankrupt, or they went into liquidation. That would obviously be trademark infringement, but they had gone into liquidation. But if they were to use your trademark in their actual advertisement that was visual, then there may be possibly a claim for copy or for trademark infringement. But I believe, and I can't be certain because I haven't revisited this, but I think if they're using it in the Google AdWords, it's actually not deemed, it's not in the public domain. And so it's not actually enabling people to think that they're you. And so I believe that they're permitted to do that. Now, a lot of people will own their copyright, their software, or just their IP generally, like their trademarks. They might have it personally, or their software might have it personally, or their domain names, they might have it personally in their name, or they might have created a two-level structure where they have a holding company that owns all the intellectual property, and then they have a trading company that's 100% owned by that holding company. And then they license the technology or the intellectual property down to their trading company. And they do that to protect against a situation where the trading company might end up being placed into insolvency. Then the holding company is protected, and all the assets are protected because they're held by the holding company, only licensed to the trading company to use. Now, the problem is if you don't have a license agreement, they say sometimes 9/10 of the law is possession. And if a liquidator was to come into a trading company and have access and see that they have all the intellectual property and everything in the trading company's possession, that there is a situation where a liquidator may claim ownership of that and control over those assets. And so normally there'll be a license agreement between the holding company and the trading company. However, the problem with that also is that a liquidator doesn't necessarily need to have strict interpretation and strict consideration to a related party transaction. So they can potentially turn a blind eye to a related party transaction, say it's uncommercial, and set it aside, and then say that that license agreement between the holding company and the trading company isn't legally binding because there's no consideration for it, there's no payment going up to the holding company, and then decide not to have reference to it and claim ownership of the trading of all the intellectual property in the trading company. However, the Personal Property Security Act overpowers the liquidator. So the Personal Property Security Act, I like to explain that when you buy a car and you get it under finance, the financier will lodge a charge against your car. So if you go to try to sell it, anyone that tries to buy it will see that the financier has a security interest over it. This is the same thing. They have a security interest, and that security interest is called a Personal Property Security Registration. In short form, it's a PPSR. Now, your holding company can lodge a PPSR against your trading company, securing ownership of all the intellectual property. So it's saying the holding company is licensing all the intellectual property to the trading company pursuant to a license agreement, and that license agreement has a PPSR clause in it, and the holding company has then gone to the PPSA or PPSR website and has lodged a PPSR against the trading company. And now the holding company is a secured creditor and the number one secured creditor over the trading company. So if a liquidator comes in, the holding company could go in and just gut the company of all of its intellectual property that it's licensed to the trading company. So if you think you have protection by having a license agreement between a holding company and a trading company, that might not be the case. Highly recommended to have a license agreement with a PPSR clause and actually go to the PPSR website and register that charge. As I was talking before, enforcement. So if someone's infringing your copyright, if someone's infringing your trademark, first normally it's a letter of demand from a lawyer that says that there's an infringement. And once that infringement happens, they demand that they cease and desist. They give an undertaking, they stop, they change their name, they transfer ownership of it. They give, there's different remedies that you can seek. And then if that person doesn't comply with 7 to 14 days, then the next step is to issue legal proceedings in the federal court to enforce your trademark or copyright. Now that can be a very, very expensive exercise, and that can be a difficult hurdle to overcome if you're a small player and a larger player has infringed your trademark, because you're now having a David versus Goliath situation where you're trying to enforce your brand against someone that has much more money than you, and you have to pay lawyers to run a case in the federal court. Now, the remedies that the federal court can grant is generally an injunction, stopping someone else from using that, which ultimately forces them to change their name. Or if they've copied your software, then changing their code. They can grant damages. So if someone's stolen your software, they can grant damages, which is the price of the license that they were supposed to have paid plus legal costs. They can grant additional damages where it's flagrancy. So the lawyer has sent a letter of demand, told them to stop, they kept on going, and they didn't. So the court can then grant them additional damages because they've refused to stop even though they knew about the infringement. And then you can also get account for profits, which is you can get the federal court to order that they have to deliver their profit and loss, all their invoices, all their finances over to you to look at, see what they've sold, what is actually infringed, and then do a calculation of what profits they've made as a result of trading using your copyright or using your trademark, and then get an order that all those profits are paid to you. There are certain circumstances where you can also bring in the director to be personally liable for that infringement, and you can potentially seek orders that those directors are personally liable. So if they want to just wind up that company and not pay you the damages or give you the account for profits, you might be able to make the directors personally accountable for it. Now let's see some other questions. So how far can a competitive company use your name? That's competition law. So that can, there's a lot of different laws that come in place when you talk about competition law, and there's a lot of carve-outs to trademark protection and to copyright protection. So copyright, someone can copy your copyright if it's used for journalism, if it's used for opinion, if it's used for criticism. And similar for trademarks, in the sense that there is ability for Coca-Cola to use Pepsi's trademark, and they used to do that back in the 90s, where it was Pepsi tastes better than Coca-Cola, and they would do the taste test, and then they would have commercials that said, 48 or 78% of the people prefer Pepsi over Coke. That can be allowed if you follow the competition rules, and those are the carve-outs and exemptions that exist for trademark and copyright infringement. And so one of the questions is, you think in Australia, .com.au domain cannot be registered unless you own the copyright or business name. That's not correct. The .com.au, you can register it. You just have to have an ABN. So you can register, like I have capitalraisinglawyers.com.au. I don't have a business name for Capital Raising Lawyers, or I might, but I didn't need that. I just needed an ABN. You don't need it. But they have recently changed it, and there are new rules that have come in play about people who do have domain names and don't have a business name to reflect it. Then there is an opportunity to lose your domain name because it's not actually being used for commercial purposes. So it's not that it prevents you from registering. What it does is it prevents you from being able to keep it. Now, one of the questions is, I've noticed a major player has trademarked all of their full names. Let's call it Super Roast Coffee. They have trademarked all the full names, but they've taken ownership of the name Supa and added registered trademark after the end. So what that means is that they're actually not using Supa as a trademark. Because if they don't have the trademark Supa on its own, and they're actually not using Super Roast Coffee, they only have protection for Super Roast Coffee. They don't have protection for Supa. And if they're going around and using Supa by itself, and they're actually not using Super Roast Coffee, what that means is they're not actually using Super Roast Coffee as a trademark. And if they're not using it as a trademark, that trademark can be removed and you can file an application for non-use where they're actually not using their trademark. And in the terms of Supa on its own, what they're doing is they probably got advice from a trademark attorney or lawyer where they're creating what's called a common law trademark. And a common law trademark is where you actually haven't registered your brand or logo, possibly because there's a conflicting one with IP Australia, possibly because they forgot to do it. And in that case, you can file an application to remove someone else's trademark on grounds that you have a common law trademark, and that common law trademark has existed beforehand. Years ago, I had a client that had been trading in Australia for many, many years, and another company came along, and they had a trademark in Australia. Another company came along, and they'd been using their brand since 1894 or something along those lines, and they're a multinational. And they came along and they've asked for a concurrent trademark. That is, you guys do this, we do that. We're happy for us both to trade in the same class. We're not going to take your trademark away from you, but we want to be able to register our trademark as well. And we do an agreement where we do this, you do that, and we both agree to both have trademarks. My client refused to allow that to happen and wouldn't move or budge and wanted to take on this company, which ultimately they lost because clearly that company had been a multinational trading since 1894. And there's no doubt that they had a common law trademark, and there was no doubt that they were going to get their registration through. And the fact that the client in Australia refused to budge because they were so stubborn, they actually lost their trademark. And the common law trademark was able to be registered. Just having a read of the questions. What if there's no profits but reputation damage? So the other side is started using your brand, your logo, your name. They haven't actually made any money, but they're damaging the reputation of your product. In that case, you get to choose whether you go for damages or account for profit. You actually don't have to elect which one you want until the end of the hearing. So you go and get an order from the court saying, let's see all your profits. And then you say, oh, you didn't make anything. Well, we choose damages. And then the court will make an award to pay, for them to pay damages. But obviously you got to be careful, because if it's a PTY Ltd company that hasn't really been trading, refuses to change their name, and hasn't made any money, you could go and hire a lawyer to go sue them. And then they just close down. And you've just wasted money on legal fees, and you might not be able to recover any money from them because they've gone. So that's where you want to try to bring in the director personally where possible. And you would obviously need to get legal advice on whether you can bring an individual in personally. One of the questions here is, I'm on the board of an industry body. We have been in the existence since 2017. We have a new member who has taken the name of one of our landing pages in existence on our website since we started and claimed the domain. She's then promoted her page on Instagram and Facebook. This dilutes not only our offering to the public, but directly damages other members. What can we do to diffuse the damage? I'm not sure if I completely understand. Do you understand what that is? No.
Yeah.
So they have a new member that's taken the name of one of the landing pages. So normally, so anyway, maybe it's a kind of product or something, and they've taken that product name and then they've created the domain. Now, that's possibly you have copyright in that. You might also have a common law trademark in that, but possibly not. It's more likely trademark. Now, that member, I think one of the things is you would have to look at the member rules. We get this kind of stuff happening a lot in terms of employees and directors and things like that doing it. And in that case, section 183 and 84 of the Corporations Act says an employee and officer of a company must not use confidential information or information of the company for the purposes to gain a benefit for themselves or gain a benefit for somebody else or cause detriment to that company. And so it's a breach of a director duty. It's also a breach of employees as well. So if an employee went and did it and you didn't have a contract for whatever reason with that employee, there's still a remedy there potentially if it was stealing information of the company or copyright material. But in terms of it being an industry body, it might potentially be a company limited by guarantee. It might be able to rely upon the Corporations Act, and if it's an incorporated association, probably not, but you're going to have to look at the rules, and you'll probably need to contact a lawyer to see whether there's an opportunity to get an injunction restraining them from doing that.
Just a quick question as well that's come through on my end around whether there's going to be a recording of this webinar. Just so everyone knows, we'll be sending out an email probably later today or early tomorrow with a link to the replay. And there'll be some details on the offer that we're just about to get into. So we'll jump into that now, given we're approaching 1 o'clock. So for everyone on today's call, we put together a special offer around trademark registration. So we've actually been running a promotion throughout March for Small Business Month around discounting our legal advice and legal and accounting advice plans. So we're providing everyone on the call today access to that sale, but we'll also be chucking in a free trademark registration. So, just some terms to that. That is just one trademark in one class, and that's facilitated through our do-it-yourself.
And from the pick list.
That's right, that's exactly right. So, just to start with there, please comment yes if you're interested in hearing more about that or taking that up. We've also put a link in there if you want to jump in and take it up straight away. Just to run through the logistics of it, if you do take up this offer, when you purchase or upgrade to our legal advice or legal and accounting advice plans, you need to book in your first consultation with a lawyer like Damin. that can be IP related. And then post that call and your consultation, we'll then provide you with a link into your free trademark registration. So you can get access to the platform there to register your trademark. Another thing to note that does not come with assistance with a lawyer. We're just facilitating the process for you, and we'll cover the fees as well. So yeah, it's a great offer. Like I said, if you are interested, please enter yes into the chat now. We will get our team to reach out to you. There'll also be a link there for you to take it up.